All right. Okay, everyone, welcome to the Buyer Broker Agreement Mastermind, set forth by Get Closed, Get Paid. We are a real estate education company based here in Florida. My name is Erin Miller. I'm a real estate attorney. I do closings, and that's about it. And I've got Kristen Jaiven. She represents real estate agents and brokers and has been instrumental in helping guide us through this buyer broker agreement new world. Although it is not new to Kristen, she's been using buyer broker agreements for years. And she's actually who introduced me to the concept of a buyer broker agreement. And we've been teaching on this topic for the last 12 months or so. And lo and behold, the last couple of weeks, folks have really started to become interested in this topic. So I know Kristen's phone's been ringing off the hook as we're helping to provide guidance to real estate agents and brokers. And of course, as you know, things are constantly changing in the real estate industry. So I encourage you to stay on top of the news, stay on top of sort of what you're hearing out in the world, be prepared to combat some of the information that you're receiving from some of the national headlines that maybe don't reflect what's actually happening in your neck of the woods in your industry. We know that there are some very smart people out there who are writing articles about what they think might happen in the real estate industry, but perhaps that might not be accurately reflected in your business. So our goal, of course, is to be as informed as possible in our industry. Pay attention to the information that NAR is putting out, that Florida Realtors, that your local boards and MLS groups are putting out to help you and to help guide you through the impending changes, but also be aware of what your consumers are viewing and listening to that perhaps doesn't necessarily reflect what's actually going on. So be able to combat that information with some facts. And then we'll go ahead and jump into our first slide, which I joke, but it really is my favorite slide. It is the attorney disclaimer slide. So we are doing these educational presentations as an educational forum. It does not create an attorney-client relationship. And Kristen, Jaiven, and I do sit on a number of committees. So the opinions that we express here do not necessarily reflect the opinions of Florida Realtors, Florida Bar, or any of those committees on which we serve. And given the nature of our industry and of course of this discussion, we do have to encourage you to be mindful of your language that you use when we're discussing compensation. This is my antitrust reminder. We are here to foster ideas and a competitive industry. We are not going to foster any discussions that will lead to an anti-competitive behavior. So this is our antitrust reminder. All right. With all of that said, we have quite a busy agenda today. As I mentioned before, we will take questions at the end. We'll reserve about 20 minutes at the end of the presentation to answer your questions, but we will turn off the recording so you can be comfortable asking those questions without being on video. But to today's agenda, we're going to do a quick overview of the recent lawsuits regarding the real estate agent compensation. We'll recap the proposed NAR settlement and anticipated practice changes. We'll do a quick review of the buyer broker agreement forms, compensation disclosure, and talk a little bit about commission negotiation. We'll talk about understanding the buyer broker agreement enforcement process, and we'll talk a little bit about commission rebates and how that might play out as we move forward, and then we'll open it up for discussion. So I do want to be clear that we might pose more questions than we do have answers because as we know, the information is changing, but as we get more information, we will of course provide further updates. So I appreciate you guys being here, and also thank you for your patience. I joke that every time we do these presentations on buyer broker agreements, another settlement or another piece of the puzzle has come about. So I will say that I am aware that Real Brokerage has, as of yesterday, decided to enter into a settlement for over $9 million in one of the lawsuits that they're involved in. Of course, I don't have the details of that proposed settlement, but I knew that happened. So I want to be, we will see further agreements for settlement or proposed settlement as we move forward. But that is the latest that we've got. All right, Kristen, want to jump right in to give me sort of a little bit of background of the lawsuits. What are the cases really about, in case someone has been, not paying attention to social media or the television the last 6 months. What has been going on? Give us a quick update, and then where are we with the Sitzer Burnett case?
Yes. So just to give you some background, some of you have already taken this class with us. We've taught this class a few times, more than a few times over the past year. And like we said, it gets changed every single time because there's always an update. The lawsuits, for anyone who doesn't know, I'm going to keep this very brief because I think at this point, most of us know, is that there was class action lawsuits brought under federal antitrust rules brought by various classes of real estate customers. The first types of classes that brought claims were classes of home sellers that argued that they should not have had to pay the buyer side commission and that there was not transparency in that, in how that was handled by real estate brokers. There was also an argument that different brokerages came together to set commissions at certain rates. So those are kind of the crux of the issues that kind of started these lawsuits. And like we said, they're brought under federal antitrust rules. There's also a whole nother class of cases where it's classes of home buyers. Those home buyers are arguing that because they were not aware that their broker was being paid a commission, they didn't get to negotiate it. And ultimately, that type of commission impacted the purchase price of their property, and therefore they were impacted, and they should have had disclosure, and they should have had the meaningful opportunity to negotiate what their agents providing services to them were paid. There's lots of various lawsuits going out. Did we keep the slide? Let's see if we kept it. I know we talked about maybe taking it out. I think we took it out, but just to give you some, because that's not the focus of today's presentation, but just to give you a background, the number of lawsuits takes up the whole slide. So we update it every time we get it, but it's like list and list and list and list and list. There is one Florida specific case. That case is unique in that it is not brought under federal antitrust rules. It's brought under Florida antitrust rules. So the first case that went to trial was the Sitzer Burnett case. That went to trial in October. It was a just over a week jury trial in Missouri, and the jury found in favor of the plaintiff home sellers and awarded damages in the amount of $1.78 billion. That's subject to treble damages, which increases that amount to almost $5 billion. In that case, important to note that there were two major players that settled that case prior to the trial beginning. That was Remax and Anywhere. Those settlements were substantial in that they agreed to $1 million payment amounts, and they also agreed to change their practices in the way they advertise cooperating commission. So that kind of happened before trial. After trial, there's also been proposed settlements. So the first proposed settlement was NAR. We had Keller Williams agreed to settle and propose settlements, and those agreements also agreed to pay settlement amounts, amount of damages, and agree to practice changes. Right after the trial, there was an initial indication by NAR that they were going to appeal that decision. The appeal never occurred because NAR, was it 2 weeks ago? 2 weeks, yeah. It's been a blur for 2 weeks.
I think it's almost a month now. I think it's 2 or 3 weeks ago. It was like March 15th, I think, it was a Friday. I don't know, things got weird. Yeah.
Proposed their own settlement. So, at first, when this first came out in October, there was definitely an indication that they were going to appeal. That's kind of all the information we were getting out of NAR was saying that they were going to appeal, but ultimately they decided to settle. The settlement is a very massive document. It's about 108 pages. To note, all settlements have to be approved by the court, so it has not received final approval. So what we're working with is a preliminary proposed settlement agreement. There could potentially be changes to it, but that's what we're working on. The focus of today's presentation is going to be what the settlement agreement agreed to for NAR member participants as far as practice changes, which are really significant. We had already seen some significant changes out of the prior settlements, which were related to not requiring cooperating commission to be offered on the MLS. You saw some changes in October, at least down in South Florida with local boards, no longer requiring cooperating commission on MLS. You could put a listing up on the MLS and offer $0. But these changes take it a step further, which we're going to get into. So Okay, proposed settlement. So there's an opt-in settlement. We're not going to spend too much time on this, but if you do want to get there, if you want to tune into the Florida Realtors town halls and things like that, they provide a little more information, or your local boards, of how to opt in. There's ability to opt in if your sales volume is below $2 billion. If you're above 2 billion, it's a little bit different, but there's ability to opt in. There's certain requirements for you to opt into the settlement. Mainly you have to be a member of the Board of Realtors or a member of NAR during a certain time period. But that criteria is set out in the settlement agreement. So if you're interested in learning how to opt into the settlement to make sure you're covered by NAR's proposed agreement, definitely tune into that. Tune into one of the Florida Realtors town halls and get information on how you would do your opt-in to the settlement agreement. Now let's get into the practice changes. All right, so the practice changes for anyone who wants light reading homework. Stars, if you pull up the 100, should we drop the, you know what? I'm going to drop it into this chat. Pause. Or Erin, do you want to chat? Can you pop the PDF of the settlement into the chat? Okay. So if you want to follow along, the practice changes start on page 27 of the settlement agreement. Okay. So if you want to follow along or read this yourself, I've read it now probably 10 times. I get a different read every interpretation every time I read it. What's important to note is that this settlement agreement is saying NAR and NAR participants are going to change their practices. As a practical matter, what you will see from here is that to implement these changes is going to require changes to the NAR Code of Ethics and the NAR MLS rules. It's also going to require changes to forms. So all of this, what we're talking about today, is conceptual until we actually see what the rules are. The practice changes are supposed to be implemented by mid-July. So hoping, Erin and I have scheduled a time in June to re-meet with all of you to go over rule changes. And we're hoping by that point, we've got new forms to review with you, and we've got what the actual new rules say. In the meantime, what we're working on is what NAR says they're going to do in the settlement agreement. So they're saying, we're going to settle this case, we're going to change your rules, and this is how we're going to change it. So we're going to go based off of that information for today. So we have an idea of what's coming down the pipeline, and then we will re-review with everyone, re-record a new class once the actual rules are published by NAR. Okay, so with that in mind, the first biggest change is that the new settlement has proposed that brokers will no longer offer seller compensation to buyer broker, or eliminate and prohibit requirements that sellers offer compensation to buyer broker and buyer representatives. That is probably not the biggest change, because as a practical matter, buyers really, or sellers never really had to offer buyer's agents commission if they didn't want to. You could put an offer on the MLS for at least $1. So yes, it's $1 to $0, but that is not as big of a change. But the biggest change is 2. Sorry, I misspoke. I said it was 1, not 2. 2 is the biggest change. 2, NAR has agreed to remove compensation from the MLS. So traditionally, a buyer's agent would typically lock in the commission rate that they were going to be paid on a transaction if they were an MLS member by making an offer on a listing that was advertised cooperating commission on the MLS. By being MLS participants, making an offer on the MLS and then a buyer's agent accepting the offer by submitting an offer to the seller's agent, that created a form of contract and enforceability as to the commission amount advertised on the MLS. You could enforce that through various NAR type of tracks, including ethics hearings and arbitration panels and things like that. And there was a mechanism to enforce that cooperating commission between brokers participating in the MLS. That is going away. There will no longer be offers of compensation on the MLS expected mid-July. So if that is the case, how does one get their compensation locked in? Does anyone know the answer? Unmute and call it out. No one's answering. Did we mute everyone?
It has to be in writing. It has to be agreed upon the parties.
Yay! Thank you, Juan. Okay, yes. It's going to have to be in writing. And how you document that is going to be a few different ways. If you are a buyer's agent and there's going to be buyer broker agreements, that's what we're getting to. But if you're actually are getting paid by the seller, you could still be paid by the seller, but that's going to have to be negotiated off the MLS and documented outside of the MLS, because you're no longer going to have the MLS rules and offer to protect you. You're going to have that documented somewhere else, maybe a commission agreement, maybe a referral agreement, something like that. But there's going to have to be documentation elsewhere. I highly recommend it's not an email. Emails, not so good when it comes to legal enforceability. It should be some sort of written document. Okay, number 3, the MLSs are required to eliminate broker comp fields on the MLS and prohibit the sharing of offers of compensation to buyers brokers. So that goes with 2. So there's no longer going to be that offer. My understanding is there is going to be an offer to advertise concessions, buyer concessions, but not anything related to commissions. The rules also seem to indicate that putting these things in additional areas of other areas of the MLS is going to be prohibited. So broker remarks, no, you can't just sneak it in there. I've seen some very creative Instagram reels and TikToks showing how you could just kind of hide it, like it's a 3-acre house, wink, wink, or something like that. That's not going to be allowed. And all of that's going to be excluded. There's going to be nothing on the MLS that tells you, buyer's agent, what the commission is going to be. Number 4, eliminate and
Kristen, sorry, before you.
Yeah.
Sorry, Kristen. So what is the purpose of 2 and 3? So the problems that they're trying to avoid is what? Real estate agents steering buyers away from properties where compensation perhaps is less than that buyer's agents want to make?
So, okay. So if you go, this is where Erin and I usually tell everyone to read widely, which means when you're trying to learn about this topic, don't only read real estate specific news publications. Read the Wall Street Journal, read the New York Times, read what everyone outside of the industry is saying. Everyone outside of the industry is kind of saying, listen, if you take the commission and the commission out of the equation and reduce the commission, there's going to be lower home prices. And these offers of compensation and this commission type of conversation needs to occur out in the open and be negotiated. So the goal, I'm going around this Erin's question here, but the goal of taking it off the MLS is that it gets negotiated and it's transparent and a conversation has to happen. So it doesn't necessarily mean a seller at this juncture, that a seller can't pay commission still to a buyer's agent, but that has to be negotiated. And we're going to get to that when we get to the new rules about buyer broker agreements. Did that answer the question or did I go around?
Yes. No, I think you did. I think also that I've read that the concern might be that if a buyer's agent was able to filter or see a particular amount of compensation on the list of homes that pop up according to the search criteria, that they may only want to show these particular homes if on MLS it shows that there is X compensation. I have not heard of that being an issue, but I read about it, so I didn't know if maybe that factored into the reason why they wanted just to remove it from MLS. But I understand the negotiation argument.
I had a question.
Go ahead.
I have realtor 80 years old. Now they've had to find around TikTok, Facebook, looking how much they will win. An additional, how is enforced that?
Okay, so it's a good question. So this gets to the big question. Let me see if it's on the next slide, just so I know. Okay, yeah. Okay, so let's go down. If it's not offered in the MLS, where can you offer it? So one area that you can offer the commission, if you are a listing broker, is on your own website. So you could advertise what you are offering on your own platform for your own listings. There are certain rules that are restricting brokers trying to kind of create a secondary MLS that aggregates this information. Because the idea is if we just take it out in the MLS, no, we still have to restrict brokers trying to create another MLS, basically. But as a practical matter, if you're advertising your own listing, you can still advertise what would be offered. But that I don't think creates an enforceable legal right to the commission. It could potentially make a false advertising claim against the listing broker if they did not honor it, but I don't necessarily think that gets you the commission. So how do you protect yourself? Sidebar that, because that's broker to broker. Let's quickly talk about buyer to broker. So we've been teaching this whole type of concept, all of these type of class action cases in the context of trying to convince everyone to use buyer representation agreements. You now no longer have a choice if you are an NAR member. Starting mid-July, you have to use a buyer rep agreement. And what's important is that the buyer rep agreement is supposed to be signed before you even show a house. So I think that's even a big change for people who use buyer agreements. A lot of agents that use buyer agreements maybe would start showing property and start doing some work and then not have the buyer commit until they're ready to sign a contract and put an offer on property. That's no longer the case. What's going to be required now based on the settlement agreement, we'll see how the rules flesh out, is that a broker working with a buyer has to have a written representation agreement signed, i.e. a buyer broker agreement, signed before they even start showing houses. That's a huge change because that's going to have to be a conversation between the agent and the broker as to what the compensation is supposed to be paid. What's also important about that new buyer version of the rules regarding the buyer broker agreement is that whatever amount you set in the buyer broker as your compensation, you can't accept more than that. That was a really big surprise for me that you could not accept more. So for example, if you are working with your buyer and you've agreed to X amount of commission, and sellers offering that plus a bonus, the new rules will say you can't accept that bonus. Or it could be a higher amount, which you do see sometimes. You see sellers offering more, you see sellers offering less. So the guidance right now that NAR is providing is that if you're in a situation where more commission is offered, you're going to have to renegotiate your buyer broker agreement and amend it. Actually get a signed amendment if you're going to offer more because you can't accept that greater amount. I think that's probably one of the biggest things I've seen because I don't know that I've ever seen anyone amend a buyer broker agreement in that fashion. But I think that's apparently the indication of what the new approach should be. And it does make sense from a negotiability standpoint. If you set with your buyer how much you're going to pay and then you're going to take more, then that should be renegotiated. Erin, you look like you want to say something.
This is no negotiation in this case. You can win more. You have to go to your client and try to convince that I will receive more for the other side.
Well, I think the theory is that there's more being offered by the seller than there's more room for negotiation of the purchase price, which gets back to why these lawsuits kind of began in the first place. Okay,
great. Yeah, so Kristen, I'm just smiling because this is one of the questions we would get when we would teach these classes live is, the Florida Realtors buyer broker agreement is clear if the compensation that is offered by the listing agent or the seller is less than, the buyer broker agreement will protect to cover the gap. But it was silent as to what if buyer broker agreement says buyer, agent gets X and the seller is offering more. And when we'd have this discussion in person, the agents in the room would say, well, of course we get the excess. Of course we get to keep, if the listing broker or seller is offering more than what my buyer agreement says, it's not, of course. In fact, it cannot happen under this proposed settlement unless there is an amendment to that buyer broker agreement. So it answers the question that we had. I'm surprised it went in that direction, but it certainly gives us a little bit of guidance as to how we can adjust it.
Some other information about the buyer broker, what the terms of the buyer broker need to be. There's been some questions in the Q&As at the town halls as to whether you can put a range or you could put some sort of way to figure out what the commission would be. The settlement actually specifically says that it has to be actually ascertainable, i.e. you put a number in there. And the example that the settlement agreement reads that you cannot do is say, it's in quotes, it's written into the settlement agreement. Buyer broker compensation shall be whatever amount the seller is offering to buyer. That is specifically listed as something you cannot do. So it's got to be a number, it's got to be a conversation with the buyer, and it's got to be set. A range has been kind of suggested that that would not be appropriate. But like I said, all of this is subject to actually seeing what NAR takes this settlement and what rules that are implemented from there. But for now, you can assume you're going to be negotiating with your buyer prior to viewing properties, setting an amount of your commission, and then if anything should change from there, renegotiating it. So that's what you need to do with your buyers at the onset. Now, could your buyer broker agreement still have language that said if the seller pays commission, you would offset the amount due from the buyer? I think that's okay. But the language change is going to have to be, if you look at kind of the buyer broker agreement that we present today, it says anything accepted from the MLS. That's not going to happen because there's going to be no MLS offered. So it's going to be compensation agreed to be paid by the seller through some other form. As far as documenting your commission between brokers, you're going to have a broker type of agreement. I do not know if Florida Realtors is coming out with one of those forms yet, but it's going to have to be some sort of form that says listing broker agrees to pay selling broker X amount of dollars. If that's the way you're getting paid. Question, it's a trick question, I'll give you that much. Can you document your commission in the purchase agreement? Erin, as a title company, would you honor anything written into the purchase agreement?
Saying that listing broker shall pay buyer agent compensation is a contract between a buyer and a seller, and the listing broker doesn't sign that contract? Absolutely not. No. Right? So when we're talking about binding a party, we're talking about binding a party who's signing the agreement. So as Kristen mentioned, the broker to broker type of compensation agreement would need to be signed by the parties being charged to the agreement. Can you pop back up to 3 and 4? I don't think we got through those two. Yeah.
Oh, sorry.
Yeah, just kidding. Yeah. Yep. So I think we stopped it at maybe 4. But as to, we can talk about this a little bit later, but as to the sales contract, again, between a buyer and a seller, there's nothing prohibiting a seller at this moment from offering a concession to a buyer. And if that concession towards closing costs and prepaids encompasses an amount that would be agreed to be paid to a buyer agent, that is fine. Again, the parties that you're binding to an agreement are the parties that are signing the document, right? So a buyer and a seller can agree to bind buyer and seller to certain behavior or credit or concession. Between broker to broker, those are the parties who can agree to bind each other.
Yeah, I think we did cover 5. You know me, I never follow directions.
Okay.
Or follow our linear path.
Yeah,
but 5, you can advertise your own listings, but not others. You can't do, you can't create your own MLS. But if you are advertising your own. Okay. Down to 7, you cannot represent your services as free. This is something you should have never been doing because nothing in the world is free. It should always be disclosed that you're being compensated. And I've had a lot of people ask this question. You know, some buyer's agents say when we're giving this presentation, well, why is it the buyer's business? Why do they need to know how much I get paid? Because it does impact their purchase price. It does impact their transaction, and they are providing services, or you are providing services to that buyer. So you have to remember all of this started because of transparency issues. So you should always be upfront with the buyer as to how much you are getting paid. Now it's going to have to be in writing. But that's the conversation. Your services have never been free, and they should have never been communicated that way. And now there's going to be rules that say that. I think the rules pretty much already do say that, but it's going to say a little more. Okay. Number 8, conspicuously disclose to sellers and obtain seller approval for any payment or offer of compensation in writing. So this is going to go to changes to the listing agreement. So the listing agreement now already kind of have, if you use the Florida Realtors form, there was already a way for a seller to agree how much was going to be offered on the MLS. So that concept is not going away. It's just going to be the sellers agreeing to how much can be offered to buyers agents. And then the language really needs to change to say how that gets offered by a buyer's agent. And maybe what conditions are placed on that. Perhaps, you know, the MLS used to have a unilateral offer of compensation for all offers. Perhaps a buyer only wants to make or a seller only wants to offer a commission if commission exceeds, or if the home set price exceeds a certain amount or something like that. If the seller wants to condition that offer, then they can do that. So that's going to be a conversation you have to have with sellers when you're determining how you're going to market the property and what you're going to offer in connection with those marketing, asks or offers. 9, require all customers and commissions that are not set by law are fully negotiable in broker contracts. And like I said, this goes back to number 7. That's always been the case. Chapter 475 requires that there be a listing agreement, and it has to be in writing, and there's certain rules as to what has to be in that agreement. It has to be for a set term, and it has to disclose what the sale price is, stuff like that, or the list price. But there is nothing set in law that says what commission amounts have to be. It's always been negotiable. It continues to be, but now you have to disclose that to sellers that services are not free. You can negotiate what we're going to be charging here today. All right. Disallow subscribers from filtering listings based on compensation. That's going to go away because the field is going away. So that one takes care of itself. Okay, so what can we do? Any more on what we can't do, Erin, before I go forward? No? Oh, you're on mute. Good. Okay, so I kind of touched on this before. What can you do? So you are representing a listing agent, or you are a listing agent representing a seller. How can you offer their property on the MLS? How can you communicate offers of compensation to buyers? You can advertise your own listings on your own website with your offer. So that is allowed. Okay. Hold on one second. I gotta mute somebody.
We're good.
Okay, thank you. Okay, and then the second thing you can do, like I said, is you can offer buyer concessions on the MLS, which is like a credit towards closing cost or something to that effect, but it can't be conditioned to payment of the buyer's agent. So that is the only thing you're going to be able to advertise on the MLS, but it has to be specifically a concession to the buyer, not anything related to the buyer's payment of commission. As a practical matter, whatever that amount is goes into the buyer's total financial outlook on the transaction and helps them to make certain decisions, especially if they do have to come up with cash to close to pay their buyer's agent at the transaction. But that's the only thing that's going to be allowed on MLS.
So, we've got a question on that point, Kristen, or related to that point. It says, what about seller, quote, seller agrees to pay buyer broker X number of dollars in the sales contract. So I know that on MLS, you can't say seller concession for buyer broker compensation, but in the sales contract, can the buyer and the seller agree to negotiate to allow the seller to pay buyer's agent compensation in the amount of X dollars?
Yeah, so I don't think it would be enforceable as to the broker. So if I was representing a broker, I would have a separate written agreement with whoever was going to pay, whether it was the listing broker, the seller, whoever was supposed to pay that amount, ultimate who's agreeing to come out of pocket for it. There should be an agreement between the broker and their client as to what that amount is, or between brokers. If the seller wants to do some sort of credit mechanism between the seller and the buyer, in the purchase agreement, in the price, then I think that would be fine. What we don't know yet is how lending rules will change in connection with these changes. So there are certain types of mortgages that would not allow that type of credit. There's certain transactions that don't allow commission to be paid by a buyer. So I just caution that that's the one unknown that we have at the moment, is how those types of credits will be able to occur when you're dealing with a finance transaction. But still, it doesn't protect the brokers. That doesn't protect the brokers. That just moves money from one line of the settlement agreement to the other line of the settlement agreement between the buyer and the seller. Yes? Is that what the question was?
Yes, no, Yes, and actually that your segue answered the following question about would the seller concession have to fall into the lending guidelines if there is financing, and I think at the moment, yes, and there could be some types of loans that wouldn't allow agent compensation to be offered for paid for a buyer or paid by a buyer in any shape or form, such as VA financing. So we're waiting for guidance on that, but that's a good question.
Okay, so let's briefly talk about DOJ. So for the past year, Erin, every presentation we give, we go da-da-da-da-da and DOJ. And we're gonna do the same today. DOJ had an investigation into NAR before kind of these cases really ramped up. They were out there, but before they were really ramped up, and there was a settlement agreement between NAR and DOJ. That was around 2020 COVID time when that occurred. That specific investigation by DOJ was into, at the time, the NAR's cooperating commission rules. The argument was that there was not transparency in how cooperating commissions were advertised. The result of that settlement agreement back then was that buyer's offer of compensation started to be visible on the MLS. And that change, if anyone remembers, happened about 4 years ago, and buyers could now see what was being offered to their agents. Just last week, there seems to be a court decision that says that decision is going to be reopened. That investigation might possibly
potentially be reopened.
There was a court decision that kind of opens the path to allow that investigation to be reopened by DOJ. So that is an investigation between DOJ and NAR about their practices before it was related to the clear cooperation policy. But there's a lot going on with DOJ. On all of this, DOJ has always kind of been interjecting itself into some of the specific cases. They challenged one of the settlements in one of the cases to say, you're not going far enough with your practice changes. You need to do more. You need to do more. So there's always a chance that DOJ intervenes and says that these practice changes don't go far enough. DOJ has said that they want to see commissions decoupled completely, meaning that sellers don't pay buyers' agents. I don't know if that's going to happen, but just know that this is not necessary. Just because we've got a settlement coming out of one of the cases with major practice changes that we can wrap our heads around and actually get some actual tactical guidance on what to do moving forward, that doesn't mean this is over, because you still possibly have the impact of DOJ making further recommendations or changes. So just know we're in the unknown for a while. We have been for a while, but we're not out of the unknown yet. All right, Erin.
So one of the tips we have for navigating the shift, of course, is to really be forward thinking. Don't put your head in the sand. Don't say, well, I've done this way for 25 years. This is how I should just practice real estate, and just assume that everything's going to be fine. You really need to be focusing on transparency with your consumers. And of course, that is always a great practice, but now you're going to be forced to be transparent about what your fee is, what your compensation expectation is, and really what you do for your buyers and for your sellers. So I know we talk about sometimes folks hide the dirty details of their transactions from their consumers, because we're trying to protect them from, knowing that we're up until, 11:30 at night on a Sunday night trying to get the deal together and that kind of thing. But I think now it's actually time to share with your consumers exactly what you do, the hurdles that you have overcome. And that would be really helpful in explaining to your current customers and also your future customers about the value that you have as a real estate agent. But you know what you do. You know how hard that you work in your transactions, but sometimes our customers don't know that. Can you please mute yourself?
With attorneys.
One moment. I think you joined. Okay, So you know what you do. Again, it's time to share with the world exactly your value. And of course, if you read the headlines, you might get the impression that a buyer's agent does nothing besides open a door. And we all know that we who are in the industry know that that is not true. So again, think forward, be upfront with your customer, be as transparent as you can with your customer. And now is really the good time to consider what your worth is, consider what your value is in a real estate transaction, and you need to be able to articulate that. Some of the resources that are available are these buyer broker agreement contracts between you and your customer. But I want you to think of those buyer broker agreement contracts as separate from your marketing tools. So the contract is what you as a buyer and your brokerage agree to do, your legal obligations for your consumer and the legal obligations of the consumer towards you as the broker with respect to compensation, communication, cooperation. But your marketing tools are separate. Your marketing tools are why your brokerage, or you particularly as a buyer's agent, are awesome, and all of the things that your brokerage can provide that perhaps are above and beyond what your legal obligation, what your legal contract says that you're going to do. We all know it's important to articulate your value to your customer, and don't be afraid of buyer agent presentations. Anyone who's been in real estate for a while has done listing presentations, and they're comfortable with the concept of presenting an agreement to a seller and explaining, these are the things that I'm going to do to help sell your home. This is why you should select me as your listing agent. Similarly, buyers agents are going to have similar types of discussions with their buyers and present the agreement and asking for money. And I will do a quick sidebar here and say, sometimes when we present this topic, we are real estate attorneys, we're not practicing real estate agents, but we get some pushback from realtors who say, wait a minute, you don't know what it's like to present an agreement to a customer and tell them what your fee is and what you're worth and hope that they agree to pay you. And I chuckle because we're real estate attorneys. We present retainer letters to customers as a regular course of business and say, these are the services that my firm will provide to you. This is what my fee is. And hope that the buyer or the seller, the customer, agrees to sign it. And if they don't want to sign the agreement, they don't value our services, they're looking, they're price shopping, they're looking elsewhere, that's okay. I would prefer to know that on day 2 or day 3 of the relationship, rather than 3 months down the line when I've poured hours and hours and hours of time into someone's case or someone's file to find out that they don't value my service and they would rather go elsewhere. So again, think of it as an opportunity to have the discussion up front so that you're not disappointed later on, so the buyer knows what to expect from you. And I will say the or else. The or else for me is the worst case scenario is a buyer goes completely unrepresented in the transaction, right? So if the buyers don't find value in a real estate agent and they're a first-time home buyer, they're not a sophisticated buyer, they maybe go directly to the listing agent, and they really do need extra handholding. They need extra assistance. They need guidance as to how to get through that transaction, and maybe they go without help. And I think that that is not the best thing for our consumers. Alternatively, perhaps they go directly to a law firm to prepare their sales contract. They say, I don't need any other assistance, that's it, I just need a contract, put me under contract and have a great day. So again, if we can't articulate our value in our industry, we can't expect our consumers to respect what we do or want to pay us for our services. So be transparent, be forward thinking, and yeah. All right, Kristen, do you want to talk a little bit about the process for enforcing buyer broker agreements? Again, we've talked about this pre-settlement, but it's important to kind of understand how they could be used in the broader scope of a real estate transaction.
Yeah, so let's just talk briefly about when you should start using the buyer broker agreement. Is everyone's plan to start using it in July or today? My recommendation would be today. It is unknown at the moment. I've reached out to Florida Realtors. I don't have a guidance yet as to what happens with transactions that were commenced, whether it's on the listing or the buyer side, prior to the policy changes going into effect in July. I don't have guidance on that yet, but I think right now, if you're taking listings or you're taking starting to begin working with buyers, you should be prepared for all the various scenarios. It is April. If you start working with a buyer today, there's a very good chance they don't buy until July. So if you don't have your commission locked in now, you could potentially be making an offer on a property that has no offer of compensation in July. And I say that because I know in the back of some agents' mind, they're thinking they have time. I don't think you have time. I think the ship has sailed and everyone should be using buyer broker agreements today, even if you're only using the Florida Realtors forms that are available now. They all need to be updated, but at least have something in writing. Even if you have to renegotiate, have something in writing with your buyers today in case they don't buy until July. So just have that in mind. Also should be having conversations with sellers. If you're taking a listing today, it is unknown whether the offer of compensation is going to be shown in July for these listings that predate that time period of the policy change. I don't know if the MLS is going to be taking off the offer of compensation, just literally delete the field and everybody's offers go away in overnight, or if it's going to be listings entered after a certain period versus before. So have those conversations now so you're prepared one way or the other how these changes occur come July, because you're already in the window for a potential transaction that you start today going into that time period. How do you enforce a buyer broker agreement? So this is a great question. So I have been enforcing buyer broker agreements for several years, and a lot of people did not use them. So if I send them to a title company might be like, oh, well, that's between, on behalf of broker, that's between you and the customer, and that's it. I hope with all of these changes in buyer broker agreements becoming the regular, that they start to be a little more taken seriously by title companies. But I don't know that for sure. So traditionally, when you had to, and when I've had to enforce a buyer broker agreement, it's been in specific situations of either the agent was circumvented, i.e. they had a contract with their broker and a buyer had a contract with the broker and the buyer used another agent to buy a transaction or went directly to a listing agreement or a listing agent. I've also used them in bridge the gap scenarios. I see that happening a lot come July. Depending on how commissions start to be offered. But bridge the gap was a scenario where perhaps a buyer agreed to pay a certain amount in the buyer broker agreement, but was able to offset only a portion of that from a listing offer. In that scenario, hold on one second, my phone's ringing. There you go. In that scenario, you would have to enforce the buyer broker agreement to collect from you would collect from the seller, but then you would collect the gap from the buyer. So that scenario I still see happening. And then the third situation is buyer default. Even if you're using the buyer broker agreement form produced by Florida Realtors, there's language that says if a buyer defaults on a transaction, the agent is still entitled to commission. If anyone has ever dealt with this situation where you were potentially entitled to a liquidated damages amount based on the deposit in a purchase agreement, and then you couldn't recover because there was the listing agreement or the listing agent didn't have a right to retain deposits, this would give you a separate enforceable action when a buyer defaults on a purchase agreement to recover your commission. We've got to mute someone. Okay. So the process to enforce a buyer broker agreement is going to be dependent on what the actual clause in the contract says with regards to dispute resolution. So the dispute resolution clause in the buyer broker agreement may say that the parties will mediate, the parties may go to arbitration, or it may say that they will litigate. So it's a contract. So whatever the dispute clause says is how you would go about enforcing the agreement. So that's traditionally how it went. I've litigated these, I've done arbitrations, things like that, depending on what the provision is, but to be determined as to how that moves forward. Number one, we have to see what the new Florida Realtors form says. And number two, we have to start to see how title companies start to treat this when this becomes the norm. I think a lot of title companies were just accustomed to looking for the transaction as what was offered on the MLS and closing it that way. That's not going to work anymore because there's going to be no information in the MLS. So hopefully they start to pay attention to the buyer agreement forms and start to handle things that way. When we're talking about impediments to enforcement, I think the impediments to enforcement on the buyer broker agreements are going to be interesting starting in July. Mainly because when you're taking a listing, you know if someone else has the listing because the listing is up on the MLS. So if you try to enter it, you're going to have a problem. You're not going to have that problem with buyer broker agreements. So there's a potential that buyers enter into multiple buyer broker agreements and commit themselves to paying commission to multiple brokers and no one knowing. So that's going to be a challenge. I don't know how we're going to get around that. But just keep that in mind because you could be working with a buyer who ends up buying with another agent and now there's 2 commissions owed. Some other impediments to enforcement that I always like to look at as an attorney that works on these cases is I like to look at the agent's actions in the transaction. If specifically in like a buyer default type of situation, if you're working with a buyer and through your maybe negligence didn't tell them about their financing obligations or financing clause, and that's what causes them to default on their transaction, then that might be a situation where you can't enforce your buyer broker agreement for commission because there's a breach of your duty under the agreement. Remember that buyer broker agreements are a contract between 2 parties and both parties have duties. So it's not just a document that locks in your commission, it's a document that says what services you're going to provide and how you're going to provide that to the buyer.
What happened now, you had the FHA loan, first buyer, today is the closing day. The only money the miss is the commission. This deal close or not close?
Are you saying FHA?
FHA, first time buyer. The only money in the transaction missing is the commission. This transaction close or not close?
So I think the transaction would close. I don't know that you're going to be able to enforce your commission. The lending rules have not caught up to this yet. So that is an unknown at the moment as to how that's going to be handled. And I hope someone comes out with some new rules with regards to that, because the alternative is you've got first-time home buyers or buyers that are using a loan product that doesn't allow commission to be paid, ending up in a situation where they have no buyer representation because they can't actually pay anyone to work on their behalf. That could be a problem. So to be determined, but right now the lending rules have not caught up.
Yep, and someone actually put in the chat what I was going to mention just a quick second ago. So it really is important for title companies and law firms who close real estate transactions to be, again, forward thinking, be ahead of this and ask for, if they're asking for commission verification forms to be completed, whether it's a jot form or a form to be completed by the agent, not only ask how much compensation are you due in this transaction, but also ask the follow-up question, and from whom? So if a portion of buyer agent compensation is due from listing broker and a portion is due directly from buyer, you need to have that information in the split. So yes, closing agents, I've never relied on the information in MLS solely to provide compensation. We would send out a jot form that asks how much compensation is due from each, for each agent. And the follow-up question, of course, is going to be now, and from whom, which side is going to be paying which portion of that compensation. So I agree, Lenora's suggestion in the chat, I absolutely agree. If you have a title company or law firm that you're working with that doesn't ask those questions and you have a buyer broker agreement, it is certainly up to the agents to be able to provide those agreements to be able to request compensation. A little bit of a side note, I believe that it will be meeting in about a month and a half or so, but I believe that the Florida Bar will also have some language that'll be updated to reflect that compensation won't just be due from the listing side of the transaction. There may be some language below the signature lines that say, in the 5-bar contract that will make it clear that escrow agents who are dispersing the transaction can disperse to buyer agents under a buyer broker agreement, for example. And that might actually be easier in Guillermo's case to enforce that buyer broker agreement as part of the transaction. But you mentioned that these are contracts between an agent and a broker. These are enforceable as contracts themselves, right? If I have a contract with you, even if the title company or law firm does not collect that compensation directly from the buyer at the time of closing, that doesn't preclude a buyer agent from pursuing enforcement after closing, correct, against the buyer. Right, Kristen?
Yeah.
Right, okay.
So you would still be able to enforce it after closing, but that becomes a legal claim. So those are not easy. As anyone who
Yeah.
has ever been involved in litigation, it's not fast. It can be a slow process. And it's really, I don't think, ideal for anyone. But that might be the scenario if a closing occurs without compensation being collected properly.
Yeah, not ideal. Okay, so we're going to talk about the current forms that exist. Again, we're anticipate these forms being updated by the Forms Committee at Florida Realtors to reflect the requirements of the proposed settlement, but just know that there is a form of EDBA -6, and it's actually TB that was revised in 2016. Again, we're in 2024 now, so I imagine the forms will be updated as they regularly are updated. But just know that this type of form is a buyer-broker exclusive agreement that sets forth the agreement between the buyer, of course, and the broker. It says the buyer will exclusively work with a particular broker to acquire property for a period of time. So again, you set your term for a period of time. You get to negotiate with your consumer how long you'd like to work with them. And regarding the property, you set the terms regarding property. One note, if you've attended our classes before, we talk about defining the type of property that the buyer is searching for as broad as possible. You don't want to say that this exclusive buyer-broker agreement is for a buyer's purchase of a condominium in Fort Lauderdale proper, because it's possible that the buyer might want to purchase a townhome in St. Lucie. So the buyers don't always know at the time that you start working with them exactly what kind of property they're going to look for. So be sort of general and broad about the property and also the geographic location. If you're looking in, sort of the South Florida Tri-County area, then list those counties if those are the counties in which you intend to work with your consumer. Kristen, did you want to mention anything else about defining the property itself?
Yes, so
as broad as possible.
New form comes out. We're teaching this as a general overview. We usually teach line by line on this contract, but because we're anticipating a new form and we've got to schedule a second class, we're just telling you conceptually, if you start using this form, how to fill it out. The way property reads in the form buyer-broker agreement that's produced by Florida Realtors, it allows you to list a price range, it allows you to list a location range, and it allows you to list a description. My recommendation is to keep that as open-ended as possible. The reason being is because buyers historically do not know what they want to buy. So if you put in there, if they come to you and say, I would like to hire you to show me property in Fort Lauderdale, Florida, up to $400,000, and then they buy in Pompano Beach, you now potentially cannot enforce your buyer-broker agreement for that sale, because they didn't buy in Fort Lauderdale. They were hiring you to look at Fort Lauderdale property. So my recommendation is to go as broad as you will go on the transaction, or as broad of a range that you will go in the state of Florida. When I'm representing buyers and drafting buyer-broker agreements, I put in Florida. That doesn't mean you have to do the whole state, though with technology, you probably could. But it does mean that you have the exclusive relationship. If you need to co-broke with someone else in a different jurisdiction or something like that, you can figure that out, but go as broad as possible. Because if you lock in to a certain geographical location or a certain price range or anything like that, you could potentially have a problem. With price range, the other thing I like to say is that, yes, you have to be conscious of your buyer's budget and what they can buy. That is critical in providing representation. You can't show buyers something they can't afford. You got to keep that in mind. But you also can't necessarily locate all the properties that they could potentially want to buy in their budget if you only go up to their cap. Things are negotiable, so you always have to go above. And finances do change. Finances change. So the example I like to give is, for my own benefit, is when I bought my own house, my husband was my realtor, and I told him I would be buying a house in Fort Lauderdale, east of 95 for $250,000. And it turns out it didn't exist at all, and nothing came up on the MLS in that price range. So if I had filled out the buyer broker, nobody would be paid because there was nothing for me to buy there. So make sure you go as broad as possible on the property description.
Perfect. Thank you. Thank you. So I like to affectionately call these buyer broker agreements real estate prenups because they do set forth the expectations of the parties, and if things go south, what to expect and the enforcement mechanisms and that kind of thing. But paragraph 4 broadly sets out the broker obligations. It is very broad and nothing that you don't already do when you're working on behalf of a buyer. It also sets forth the buyer's obligations to exclusively work through that particular broker for the acquisition of property. This buyer broker agreement form does offer the opportunity to have a retainer. It is up to you and your broker whether you're going to require a retainer in your transactions. Paragraph 7 offers compensation. Again, I imagine this paragraph being tweaked quite a bit, but essentially you are negotiating the compensation that you're expecting for your work on the property or to acquire the property. There's also a protection period, similar to the listing agreements. There's a protection period for a period of time after the termination of the agreement, for which if any of the properties that you showed the purchaser or introduced to the purchaser are closed, that protection period, of course, is terminated similar to as it is under the listing agreement, that if the buyer enters into a new buyer broker agreement with a new broker, that cuts off that protection period. This one also has an early termination clause. So either broker or buyer could terminate this buyer broker agreement early, which is, I suppose, good news for a buyer if they're not being served properly by their agent. Kristen, I know you're not really a huge fan of the early termination clause at all, because you think that the buyer and the buyer's agent should have this protected agreement, and if the buyer's agent shows the property to a buyer, they should be compensated for their services. Yes.
So 2 things to note about the Florida Realtors buyer broker agreement. It can be terminated at any time. So you could be working with the buyer and they could terminate it. So that's problematic. The second thing that's problematic about this form is that if a buyer stops working with you and then signs another buyer broker agreement with another broker, it potentially cuts off the protection period, meaning that houses you introduce them to, you're not going to be protected for either. Those are 2 big issues I see with this form. Hopefully that get resolved in the new drafts, but those offer some weak protections for you working with buyers, especially if they terminate your services and make an offer on another buyer or property that you introduce them to. You could potentially not be protected. So.
Yep. So this also sets forth the dispute resolution provision. So the parties have to agree to go through mediation first. If the settlement can't be reached in mediation, then there is an arbitration requirement. Again, not all buyer broker agreements will have an arbitration requirement. So look at your form, look at the new forms that come out. This can also be assigned. This agreement can be assigned to another broker. This might also be helpful. Let's say that you and either you change brokerages or you decide that this buyer is not going to be, looking in your particular farm area. You don't intend to actually show them property in Miami-Dade County because you live up in Martin County, for example. This can be assigned to another broker. And of course, probably most importantly, it sets forth the brokerage relationship provision. So this one happens to be the TB form, transaction broker form. So it sets forth all of those brokerage relationships. There is a paragraph 13 with a bunch of blank lines that I, as an attorney, get nervous about showing folks the blank lines on a contract. I suggest if you're going to insert any special clauses, make sure that you have the clauses reviewed by your broker, reviewed by counsel, to make sure you're understanding what you're putting in there and obligating your brokerage to. This form is signed by the buyer and by the real estate associate and by the broker. And there's also a showing agreement. So this is an agreement that you use, perhaps you've got a lead from the internet, you set up a bunch of, scheduled a bunch of appointments for a Saturday morning to show a buyer these 5 particular properties. This showing agreement is the FR form SA-3X. This showing agreement form is for specific properties showed to a buyer. So you list the property addresses on this form, and the buyer essentially enters into a contract and closes on those properties. There is an agreement for compensation to the broker. This is not an exclusive agreement. And again, it only requires compensation if one of these 5 properties that was shown goes under contract and is actually closed. And there is no such thing as an early termination. It is an agreement for compensation for these particular properties. I would also anticipate there being perhaps different forms that are offered. I know Florida Realtors did put out a retainer form. We can include that in our recap. There is sort of a retainer agreement form for folks to enter into. I imagine all of these forms will comply with the requirements to indicate that compensation, of course, is negotiable. We all know it's negotiable, but it will include that sort of disclaimer. The compensation is negotiable. But these 2 forms do exist now. If you need a form, your broker doesn't have their own particular form, there is the buyer broker, exclusive buyer broker agreement and the showing agreement that are available in your forms packages now. And I agree with you, Kristen. I don't think there's a reason to wait until new forms are developed. But I do know that the goal for Florida Realtors and for the Naples Area Board of Realtors is to have their forms available by May 31st. So in final form, so that based on the information that we have so far. Of course, as the rules development process proceeds, those potential changes could be tweaked, and we'll stay on top of that as well.
Yeah, there's also a retainer agreement that Florida Realtors produced. I don't know though that that's going to be sufficient under the new settlement agreement. I think if I had a crystal ball, I think the new rules will require that any buyer rep agreement that you have signed prior to beginning to show property, which is now the timeline of when you have to have it signed, that it actually reflect specifically the compensation structure that has to be paid, not necessarily just a retainer. I don't even know that the showing agreement is going to be sufficient. So those are the 2 forms you have out there now. I recommend, like we said before, getting those signed now because you are already in the window for this to happen, for transactions to be potentially impacted by the policy changes. And yeah, hopefully sooner rather than later, we have a new form to show you all.
So some MLS boards have already put forth a compensation disclosure. I think this was from the Broward, Palm Beaches, and St. Lucie County Realtors, a board that has a compensation disclosure form in their forms packet, and also sort of the do's and don'ts of commission negotiation. So just know that is those forms are available to use in your transactions. But essentially the compensation disclosure says, hey buyer, hey seller, our compensation is negotiable. And again, we're saying it always has been, but now we're putting it in writing to our consumers. And then do you want to talk briefly, I think we touched on it for just a moment, but we're getting credits in our sales contracts. We did talk about how if the transaction is a finance transaction, that we'll need to take into consideration any sort of lender caps on credit towards closing costs and that kind of thing. But what about like a sort of a commission credit or a commission rebate? And I've got the anti-kickback statute on the next slide, but do you want to talk about that sort of generally?
Yeah, so when we first started teaching this class, we taught these separate. We taught commission kickbacks and credits separate from buyer broker, and now we realize more and more they seem to be going together because now commissions are going to be negotiated a little more, just negotiated more. That's the purpose of all this. Generally, a licensee cannot share commission with with a non-licensee in the state of Florida. There is an exception to rebate parts of commission to a party to the transaction, as long as there's full notice and disclosure to all parties. That is a rule coming out of your licensing rule. So you will not have a licensing issue if you do rebate in a transaction and you follow the statute to do that. The statute and the rules are up on the screen. That does not mean, though, necessarily that that's compliant with lending rules, which have specific guidelines related to how much credits, what can be credited and the amounts of the credits. So like we said, the one unknown at this juncture is how lending rules will change. But do know that this kind of, this is out there and this is a tool potentially. I see this as coming in more and more at play in situations now that the overage is not allowed to go to the agent without renegotiating their buyer contract. So if there is a situation where you've contracted with your buyer for a certain amount of commission, the seller's agent ends up offering more than that. Now you've got this rule potentially that says you can't take that overage. So what do you do with that money? Do you renegotiate that in the purchase price? Or do you potentially say, okay, go ahead and offer that and I'll rebate that over to my buyer? All that is a fluid conversation that's got to occur in the midst of the transaction. So just keep that in mind that this is out there. And depending on the specific licensing, or is that licensing, lending rules at issue in your transaction or at play in your transaction, you could potentially maybe use that. That also potentially any credit from the seller over to a buyer could potentially help them with closing costs if they do have to come out of pocket for certain things.
Thank you. Thank you. So our next slide is really a list of resources. Again, in our recap email, we can send this to everyone who's here on the Zoom. These links are clickable, so you can go through. What I'd like to point out is the most recently added link is actually the very first one regarding our settlement. That is the link that I put into the chat that goes directly to the webpage where there is the video that Florida Realtors produced a couple of weeks ago. And again, if you have not watched that video, it is really helpful to hear from Florida Realtors and how they intend to move forward. And they go sort of in depth as to what the rule requirements are. So I encourage you to jump there, but also your local boards are going to have some resources to help you not only understand the legal issues, but also make sure that when you're discussing with consumers, you're providing the appropriate disclosures and appropriate information.